Hello, everyone, and welcome to today's webinar presentation. What would overruling Chevron mean for labor and employment law? As many of you know, employers today often struggle to comply with federal regulations issued by agencies like the DOL, NLRB, or the EEOC. It is important for employers to understand the Chevron and Loper cases, including the impact it may have if the Supreme Court overrules the Chevron case. Before getting further into today's topic, I would like to take a moment to introduce myself and my organization, complianceHR. My name is Stephanie Zielinski, and I'm the Marketing Director. You may recognize my name from the invitation emails you received for today's event. Some of you may even have emailed me directly about this presentation. To prevent a few popular questions from entering our Q&A box today, I would like to let you know that this presentation will be recorded and it will be emailed to every one of you attending today and anyone who is registered for this event, even if they could not attend. So please keep an eye on your inbox for an email from complianceHR webinars. Now, a bit about complianceHR for anyone who may be unfamiliar. complianceHR is a joint venture between two incredible and innovative organizations, the AI technology company, Neota, and the law firm, Littler. complianceHR delivers expert employment law guidance in a fraction of the time. Our goal is to simplify the complexity of employment law, something we will learn a lot about during this presentation. And to achieve that goal, complianceHR offers a suite of technology solutions around critical HR compliance topics, like employee overtime, independent contractor classification, employee handbooks, onboarding, leave, and many others. Today, however, I would like to introduce you to two solutions that we call Compliance Essentials, PolicySmart and the Reference Center. PolicySmart is a comprehensive handbook solution that provides you with federal and state compliant templates, a compliance policy timeline, handbook checklists, and even automated emails to alert you on new legal changes going into effect. The Reference Center is a newer solution that combines many of our other rapid reference tools. This solution helps you and your team quickly answer employment law and HR compliance questions. With information covering a wide range of compliance topics and deep insights that bridge multiple compliance concerns, the Reference Center was created to help HR and legal professionals do their jobs more effectively and efficiently. Having easy access to reliable employment law information and an updated and compliant employee handbook is essential. Now, you may be asking, how do these resources fit in with today's topic? Well, should the Chevron case be overruled, it is likely that we will see labor and employment law changes, which Alex will dive into soon. Having an up-to-date and trusted solution with data and information directly sourced from Littler to inform your team of these changes and streamline many of the HR and compliance workflows to make these updates will save your organization time, money, and unnecessary stress. If you're interested in learning more, a survey should have popped up on your screen during the last slide. You may have to exit full screen mode to see it though. If you would like to receive a complimentary demo of the Navigator Suite, simply answer yes, and I will send your contact information to our team of experts to have a deeper conversation with you about your compliance strategy and how complianceHR can support it. In addition to a demonstration of our solutions, your organization may be eligible to receive a free trial of our products so you can see precisely how much time and money they can save you. If you're not sure at this time, don't worry, I will ask once more before we conclude today's presentation. You can also request more information through the question box, or there should be a link in the resources panel. Of course, you can always go to our website too, compliancehr.com. Now, today I have the pleasure of announcing our presenter, Alex MacDonald, who is a shareholder with Littler's Workplace Policy Institute based in Washington, D.C. Alex focuses on emerging legislation and regulation, making him an expert resource on today's topic. Unfortunately, Tammy McCutchen, who you may recognize as the former U.S. DOL Wage and Hour Administrator, a Littler alum, and former complianceHR consultant, could not join us during today's event. So Alex will be flawlessly handling this presentation independently. Alex, I'll go ahead and pass it over to you.
All right. Well, thank you, Stephanie. I appreciate that. It was a very kind introduction. I'll try to my best to make it as flawless as possible, though I'm not as sanguine as you are. This is a topic that, in my experience, has garnered more attention, at least in sort of crunchy legal circles, than I have ever seen any discussion over a single Supreme Court. Well, I mean, that might be a little bit of an exaggeration, but it's certainly up there, which may strike some people who are not, pickled and in administrative law and thinking about these things all the time, as we are at the Workplace Policy Institute, may find a little strange. Chevron is not like Brown v. Board of Education, which in the broader public is one of these super famous Supreme Court cases, and yet it is silently, or at least not silently, but quietly, one of the most influential decisions the Supreme Court has issued in the 20th century, and continuing on. I say that it's been cited more than 15,000 times. It is an extremely important decision. And so we're going to talk a little bit about, to start, just to orient the audience, because I understand not everybody spends their free time thinking about these things. What's important about Chevron? Why the Supreme Court is talking about it right now? What could possibly change? And for this audience specifically, what could change about federal employment and labor law that will change the way businesses approach compliance? That's where we're going to try to focus today's discussion. And you see this first slide right here. We're just going to start off as an overview just so that everybody is oriented and has the right framework to think about this. What is Chevron? We keep saying this. Chevron is obviously a company, but it is also a famous Supreme Court decision from the 1980s. The decision itself was sort of a in the weeds Environmental Protection Act case. It involved, or I'm sorry, it was a Clean Air Act case involving the EPA, the Environmental Protection Agency. Involved the question in that case was whether the EPA could correctly, by regulation, treat multiple plants as a single source for emission regulation. Really nerdy in the weeds stuff, which may tell you why the Supreme Court was so eager. They'd been bombarded with these administrative cases over years, to develop a framework that would allow them to not get in the weeds so often on these really specific scientific judgment calls. And that the solution that the Supreme Court ultimately came up with in an opinion written by Justice Stevens was the Chevron case. And what that case said was, we understand that when Congress writes a statute and assigns authority to a federal agency to implement that statute, that Congress wants the agency to have some degree of discretion about how to implement it. And so we are going to interpret statutes in the following way. If the statute is ambiguous in any way, meaning it could be read two different ways, at least, reasonably, and the agency adopts an interpretation, and that interpretation is reasonable, then we, the court, are going to defer to the agency's view on what the statute means, even if reading that statute to begin with, we might have read it a different way. And this has become, you can see here on the next slide, the famous Chevron two-step. So there's two steps. One, is the statute ambiguous? Two, has the agency adopted a reasonable interpretation? In which case, the court assumes that this is a policy judgment that has been delegated to the agency by Congress, and therefore the agency's view is law. The court will enforce it. That's relatively simple to understand at the top, but what does that end up meaning when we're interpreting specific statutes? Why is I apologize, I skipped forward a slide, but we'll just go with this one. Why is that so important? Well, it's so important because that principle that the court adopted in that case applies to most areas of the law that are important in the United States economy. And the reason is administrative law has expanded to include many areas of traditional state authority, many areas of traditional federal authority, so that agencies, now that they have this sort of broad discretion and deference that they receive in courts, have become the engines of policymaking in this country for many areas, including labor and employment law. I'll give you a couple examples. just recently, there was some back and forth over a rule defining what counts as an independent contractor under the Fair Labor Standards Act. There is a definition in the statute. The statute is relatively ambiguous. It says that an employer is someone who employs an employee. An employee is somebody who is suffered or permitted to work under the statute. So it doesn't really, answer many questions in the real world. And so the way we worked this out over years and years and years is there was judicial interpretations. Courts put their own gloss under the statute and came up with various tests and definitions that they applied to determine whether a worker was an employee or an independent contractor under that statute. Well, now the Department of Labor in the last couple of years has proposed two major regulations defining this term. If agencies can do that and receive deference in court for their interpretations, then that removes some power that courts had exercised over decades and places it in the hands of a federal agency. So it's really about who decides as opposed to what's being decided. Though obviously who decides can change the answer depending on the political valence of an issue, the particular administration, economic conditions, et cetera, et cetera. I mentioned that Chevron, before these reasons, has been cited more than 15,000 times. The count is probably higher now. That count was done in 2019. Chevron's cited hundreds of times every year by federal courts when they're interpreting agency regulations, and so it's surely much more than that. And the one other thing I'll mention before we move on is every major federal agency is touched in some way by Chevron. What do I mean by that? I'm phrasing it that carefully because not all agencies invoke Chevron specifically. There are a few agencies, particularly the National Labor Relations Board, which has different decisions which apply basically the same framework. There's an old case called Hearst, which was decided in the 1930s, involving the National Labor Relations Board's interpretive authority, but it came to essentially the same conclusion, which is when the statute is ambiguous, we're going to defer to the agency's expertise. So we talked a little bit about its effect on labor and employment law. I guess, the one thing I'll say before we get a little bit more into the weeds is people don't realize, or many people don't realize, the degree to which modern labor and employment law actually is administrative law. Most of the law that your average attorney you're going to talk to at Littler about your labor issues or your wage and hour issues or your discrimination issues, your federal compliance issues. Most of these rules that they're going to be explaining to you or the issues they're going to be walking you through don't come directly from court decisions, or at least not initially, and the courts obviously get involved, nor do they come from the statute itself. Often they are coming from interpretive regulations that agencies have issued. And this is across the spectrum in labor and employment law. The NLRB issues regulations, though it also makes a lot of policy through adjudication, which is a different mechanism for developing policy, but gets essentially the same judgment or deference, excuse me. The EEOC occasionally issues regulations, though it's not as active as some of the other agencies. The Department of Labor obviously issues regulations fairly frequently, actually, under multiple statutes. And OSHA is another agency that is pretty active in the regulatory space. They all have invoked Chevron in the past and will continue to do so unless something changes. Okay, so that's what Chevron is and how it plays out in the federal labor and employment space. But why is it something changing now? Well, a few trends have converged that have led the Supreme Court to take up a couple of cases and reconsider whether Chevron makes sense. Ever since Chevron came down, and the thing to keep in mind is some of this has political valence, and I don't mean to make this is not a political presentation, but when Chevron originally came down, it was actually seen as a conservative-leaning decision. At that time, conservative political parties controlled the White House, so they controlled the agencies, and so any decision that was deferential to the agencies was seen as pro-Republican, pro-GOP. Obviously, things have changed since then, and this changes every time we have a presidential election. And the intellectual climate has changed in the intervening decades. And what do I mean by that? Well, originally, even when Chevron came down, there were criticisms, but those criticisms have become a drumbeat over the years. You've got a lot of scholars out there writing about why courts shouldn't, quote unquote, defer to an agency's interpretation. We can walk through those criticisms. I think they're very interesting, but maybe not necessary for to understand what you need to do to comply. But I will just sort of survey them a little bit. One criticism is that by giving agencies additional policymaking leeway, what the courts are doing is actually encouraging Congress to delegate greater and greater degrees of authority to agencies. So what do I mean by that? So if Congress knows that agencies are going to get a free pass in court, and Congress may, as a body, may not want to make a controversial decision on a particular issue, what they can do is write an ambiguous statute and say, agency, you write the rules, and then they just punt to someone who doesn't have to run through the next election cycle. That's one criticism of Chevron, that it has this sort of systemic bias toward, encouraging Congress not to do its job. Another criticism is that it has enhanced the power of the president. Made it sort of the quote unquote imperial presidency. The president appoints the heads of the agencies write all the rules. We're effectively doing lawmaking through one branch. So the president has all the power. And by extension, by expanding the president's power, we've made presidential elections more toxic because the stakes are higher. You can take that argument for what it's worth. I'm not sure I actually believe it. I think presidential elections were toxic going back to, the Jefferson versus Adams election. But that is out there, just so you know. Another pretty common criticism is that it just denigrates the role of courts in our system. So there's a school of thought that the job of courts, according to the Constitution, Article 3 says that courts are supposed to be resolving case and controversies, and part of that duty is to quote unquote say what the law is. And if a court is not actually interpreting the statute or giving it its quote unquote best reading, but instead outsourcing that job to an agency, then the court itself is not doing its job. And so you're draining some responsibility from courts, you're draining some responsibility from Congress, and you're collecting it all within an administrative bureaucracy. That's sort of the thrust of the intellectual criticism of Chevron. The other trend that has led the court, or may have led the court, I don't actually have a crystal ball into any of the justices' minds, but that has led potentially to their willingness to reconsider Chevron, is there's been a ton of litigation and back and forth in the administrative space. So just talking about labor and employment law again, in the last decade, nearly every major labor and employment regulation issued by a federal agency has been challenged in court. There has been litigation. There have been lawsuits. And just for full disclosure, Littler has represented, in particular, members of the workplace policy team have represented plaintiffs in many of those suits. There are suits right now over the most recent update to the Davis-Bacon Act regulations, which is a prevailing wage law for federal construction contracts. There is a lawsuit right now over the Department of Labor's independent contractor rule, which I mentioned at the top. There is a lawsuit over the NLRB's joint employment rule, which I mentioned at the top. And there are many other lawsuits out there pending, and there have been lawsuits in the past over overtime, over another independent contractor rule, over a interpretation by the Department of Labor of the persuader rule. The persuader rule deals with contractors who essentially persuade employees in the course of the unionization campaign. But the point is that all of this litigation has led to many rules being struck down, some being upheld, and then a lot of back and forth in the administrative process. So again, I'm going to circle back just to illustrate this point to the independent contractor rule. There was a rule issued in early 2021 at the tail end of the Trump administration. That rule was immediately pulled down by the Biden administration. Then that rule was restored by a federal judge. and now the Biden administration is issuing another rule. So there's been, 3 flip-flops in 3 years over the same issue, and at some point it stops looking like law, it starts looking like politics, which may make some people sitting on the Supreme Court uncomfortable. Um, what actually is happening, though? So that's all the reasons we might want to relook at Chevron. There are 2 cases that are up at the Supreme Court right now. There was originally Loper Bright Enterprises, and the Supreme Court accepted a second companion case called Relentless. And just for context, they accepted the second case so that the ninth justice, Justice Jackson, would be able to participate. She had participated in Loper Bright when she was a lower court judge, and she sat on the panel when it was heard. So the reason they took another case on this issue was so that she could fully participate and they could have a full court. Both of them, again, and this is true often when we talk about administrative law, both of them involve sort of this recondite issue under the Magnuson-Stevens Act. It's a law about federal fisheries. It's about whether, the Department of Commerce could make fishing boats pay for the monitors who ride around on the boats. It's, a very specific question. Both courts below, the First Circuit and the D.C. Circuit, cited Chevron, said the department's resolution of this issue was reasonable. The Department of Commerce decided, yes, we can make you pay for these monitors on the boats. And then they were both accepted for review at the Supreme Court. And the question here is a little tangled. Let me explain this. So the Supreme Court accepts cert on specific questions, and cert is short for certiorari. It means essentially review. It's a fancy Latin phrase for review. And the question in both cases was, should Chevron be overruled, or should Chevron be clarified to say that statutory silence on an issue is not ambiguity? So what work is that second part doing? That second part potentially gives the court an out, and we'll talk about what it could mean for future resolution here a little bit later in the program. But I just want you to know that there's a potential second subsidiary question here. It's not just should Chevron be overruled. So that was obviously I say obviously, but it was the focus of the oral arguments in both of these cases. Justice we're talking about. So we walked through a little bit. These slides give you a little more context. What I will say is, talk about oral arguments a little bit. There were some justices going in who we expected would be interested in overruling Chevron, and we thought they would be because they've written that they think Chevron is wrong, or at least deeply misguided in the past. Those justices tend to sit on the more conservative wing of the court. We weren't all 100% sure about how the middle of the court would react. We expected that the sort of progressive wing of the court would be more interested in maintaining Chevron and upholding agency discretion to do rulemaking. The arguments basically played out that way. I think the concern that you saw emerge from some of the justices in what I guess could be described the middle, though it's not always perfectly accurate to describe the justices this way, but at least on this issue, Justices Roberts and Barrett were asking questions about potential disruption from overruling Chevron. So given that Chevron's been around for decades and decades and has been cited so many times and has become this pillar of administrative law, what does this mean for all, if we were to overrule Chevron today, what would this mean for all of those cases? And you could see a little bit of reticence there. So it wasn't entirely clear that everybody was on board with going outright to overrule Chevron. But there were some justices who seemed pretty ready to do that. So that's a lot of lead up, I think, but that gives us a pretty good framework for how we should be thinking about this in the labor and employment context. Chevron is a bedrock decision of administrative law. Modern labor and employment law is basically administrative law. So specifically, how is this going to affect rulemaking and the law in the labor and employment space going forward? Well, so the most immediate impact, and this is, take this from a grain of salt. This is somebody who deals with, challenges to federal regulations and, every day. It's a big part of what we do here at Lillard and the Workplace Policy Institute. There are certain rules that could be affected immediately, pending rules. So I've mentioned the independent contractor rule multiple times. I mentioned the joint employer rule very briefly. There's also a proposed Department of Labor overtime rule hanging out there. All of these could be affected in varying ways by overruling Chevron. What do I mean by varying? I'll be very specific about these potential rules. So I mentioned that the NLRB receives a different form of deference, not strictly Chevron deference that comes from Hearst Publishing, but that decision is based on essentially the same rationale that Chevron is. The agency has been assigned by Congress to administer the statute. The agency has specialization and purported expertise, and so the statute means in a given context. I could have been describing the rationale for Chevron or Hearst there. If the court were to overrule Chevron in a way that disavowed that rationale, that no, regardless of the agency's expertise or regardless of whether the agency administers a particular statute, courts, this is sort of the maximal version of overruling Chevron, courts must decide what the law means in the first instance. They cannot defer to agencies. That would affect the type of deference that the NLRB is getting in court, even though the NLRB does not, strictly speaking, rely on Chevron. Its deference is this older form. So you could see that kind of decision affect the legality of this pending NLRB joint employer rule. Same with a little bit different issue with the independent contract rule. And again, I don't want to make this too in the weeds for this audience, but this is another criticism that we should talk about of Chevron. Chevron's only one form of deference that federal courts give to administrative agencies. There are actually differing tiers of deference. There's what used to be called Auer deference, which is now called Kaiser deference, which is a form of deference that agencies get when they're interpreting their own regulations. And then there's another form of deference called Skidmore deference, which is not deference per se, but it's more about, well, we respect the agency's expertise, we expect its guidance, and so we're going to give its interpretation whatever weight it's due from its persuasive value. Which really, when you say it that way, you realize that isn't deference at all. That's just saying if your interpretation is persuasive, we'll accept it. That's technically what the Department of Labor is relying on with this independent contract rule. But again, if the court were to come out with a maximalist version of this overruling Chevron rationale, that no, courts must be making these decisions in the first instance, they can't be deferring to the views of the agencies, that could affect even Skidmore deference. But that wasn't really the tenor of the oral argument. The oral argument seemed to be focused on Skidmore as a fallback, as opposed to throwing Skidmore out with Chevron. But again, this is going to depend on how exactly they do this. The last one here, the overtime rule. This one's actually interesting. So the Department of Labor does have delegated authority from Congress to define certain terms in the Fair Labor Standards Act. And among those terms are what are the so-called white-collar exemptions. Most of the people on this call are probably familiar with these. These are your administrative employees, your executive employees, your professional employees. These are folks who are not eligible for overtime or minimum wage. But those terms are not really fleshed out in the statute. Instead, what the statute says is that they are, as they are defined by the Secretary of Labor from time to time. Well, the department has historically used that authority to define these exemptions using multiple criteria. One of which is that they are paid a minimum salary level. The department's rule addresses that minimum salary level. They're proposing to raise the minimum for qualifying as an exempt worker to potentially more than $60,000, but they still haven't given us the final number. In any event, there have been some justices, I say some justices, there's been one justice in particular, Justice Kavanaugh, who has written that perhaps that the whole salary basis and minimum salary component of this definition doesn't make sense at all. And so historically, the department has received Chevron deference for these interpretations and these multiple criteria that go into the definition. If the court were to come out and say, well, that's wrong, we shouldn't be deferring to agencies at all, even when they've been delegated authority, as the department has in Fair Labor Standards Act, then that could call this rule into question. You've got at least one Supreme Court justice saying that we shouldn't have a minimum salary at all. And if we're saying now that agencies get no deference on this point, then there could be courts who are willing to look at that. Say, actually, we think this is invalid. This is not what the statute means in its best reading in the first instance. So, there are major potential implications for rules that are hanging out there. Future rules. So obviously, the issue wouldn't stop with pending rules. Agencies would have to analyze the decision, change their plans, adjust to the new status quo, and perhaps adjust their regulatory agendas. Well, what do I mean by that? If I'm sitting in a general counsel's office at a federal agency, which I used to do, and I'm thinking about, we have a regulatory agenda. We used to get deference for our major rules, but now the Supreme Court is saying, and lower courts are going to say, that we don't get any kind of deference, then maybe that rule looks different. And what do I mean by different? Probably if you're being, because look, it's expensive, it's time consuming, nobody wants to write a rule and just see it get struck down. So what agencies are likely to do is be more small c conservative in the way they regulate, meaning they will stick closer to the statute. They will be really only filling in details, things that are clearly not changing the meaning of the statute, things that are well within the realm of judicial interpretations of the statute, just, biting around the edges as opposed to taking big swings on policy making through rulemaking. That's one effect you're likely to see. And I actually want to make this concrete for people, so I'll give you an example. Right now, the Department of Labor is considering, it has proposed and is considering regulations that would create a new labor relations program for workers who work under the H-2A visa program for farm workers. This regulation that's been proposed would effectively create a mini National Labor Relations Act that would cover workers under that program. It's brand new. There's really no textual basis for it in the statute. They're sort of hanging their hat on some very thin statutory language, but they think this is good policy, and so they're going forward. It's a big swing. I don't think anybody who is being neutral about this would say that it's not. But if it's going to survive, it's going to survive because the agency gets deference from the courts. The courts are going to defer to these big policy changes. They're going to say, well, I don't really see that in the statute, but if you say that's what it means, I suppose this is reasonable under Chevron, and so I'm supposed to defer to you. That's really the only way you can do that, through regulation. If you can't get that kind of deference, you're more likely to do small bore things like changing filing procedures and these sorts of things. So more modest rulemaking. Probably fewer rules, right? Agencies are not going to be making widespread or policy changes through rules. They're going to be nibbling around the edges, and they're probably going to be doing it less frequently. Because again, nobody wants to have a rule overturned. Nobody wants to go through the time and effort to pass a rule that is going to be a dead letter as soon as it hits the courts. And so they're really only going to regulate when they're more sure that their rule is going to be defensible, and fewer rules under a regime that no longer has Chevron will be defensible. And so you're probably going to see less rulemaking. I have here more policy making by statute. That's debatable, and I'll tell you why it's debatable. Some scholars think, and we mentioned the criticism of Chevron at the top. Some scholars think that what you will see if Chevron is no longer on the books, that Congress will become more active. We do have a complex modern economy. Technology is speeding this up. Globalization is speeding this up. Automation, population growth. I mean, there are reasons to think that we have a felt need for policymaking to address modern issues. Somebody's got to do it. If it's not agencies, who is it? Well, Congress is the entity that is most obvious. I mean, they are the ones assigned by the Constitution to be writing laws. There are some proposals that would make that easier. There's something called the Reins Act, which would allow, essentially, it would require an agency. The agency would still write the rule, then the agency would send the rule to Congress for an up and down vote. That's well, I apologize. You're getting the live treatment. I have a call coming in through my phone. So that's one proposal that would return sort of this policymaking impetus back to Congress. Whether you think that's likely or not, I guess it depends on how cynical you are about the state of Congress or not. One other thing you might see, and we don't have this on the slide, but I think it's actually pretty likely, is if I'm an agency, because the agencies are still going to know, look, Congress is frozen right now. Maybe it'll get fixed one day. We can't really expect Congress to start, passing rafts and rafts of laws to address these problems. We know we're not going to get deference on our regulations. Maybe what we need to do is start developing policy through litigation in courts. That would involve filing lawsuits, suing people, and then claiming in the context of that lawsuit that the statute means X, right? I'm going to take a position in regulation that the best reading of the statute is X. And if a court accepts that, then I don't have to worry about Chevron. Now I have a court decision that says my interpretation of the statute is reasonable. I don't have to worry about deference. The court did its job. I did my job. That may be, so you may see an uptick in policymaking through litigation. Agencies may start filing strategic lawsuits to establish legal principles. That's a possibility. All right, so we have a little bit more detail on some of the policies I was just walking through. There are a few other areas that may be affected by this change. I mentioned this joint employment thing a couple of times. I won't run through it again. We mentioned the salary basis rule. We don't have to talk about that. We have card check on here. Card check is, for those who don't know, card check is an alternative way for a union to get recognition in a new employer. The traditional way is the union goes in, it collects cards, and then it files those cards with the NLRB, and the NLRB conducts a secret ballot election. And if the union wins the election, it becomes the certified representative and can represent employees in bargaining exclusively. There's an alternative way, and that alternative way is the union, rather than filing for an election, just hands the cards to the employer and demands recognition. The employer looks at the cards, counts them up, sees that the union represents the majority, and recognizes the union. That has been greatly expanded through some recent NLRB decisions. But card check is only one example of this phenomenon. We've seen some pretty aggressive interpretations, both by the General Counsel of the NLRB and the NLRB itself, that are causing some consternation. You even see, some discussion and a few lawsuits saying that the NLRB is unconstitutional because it's doing these things. That might slow down if you had strong pushback from the Supreme Court and then ultimately from lower federal courts on deference. Because again, these are adventurous, I'm describing them as adventurous. I want to be as neutral about this as possible. They are novel interpretations. No one will tell you they're not, of the statute. And agencies may be less likely and may be less able to take novel views of statutes, including the National Labor Relations Act, that push the boundaries on what agencies can do vis-a-vis private parties. Card check's a good example of that, but the board has done several things that could fall into the same bucket. All right, so we've talked a lot about the background, what might change, what might not, what we actually think is going to happen. So I'll give you my view, and keep in mind this is one person's view. You may get different views from different lawyers, but as somebody who follows these issues pretty closely, listened to the oral arguments, read the briefs, has been living with Chevron for his entire legal career, I don't know that there's going to be so what I will say is what's unlikely to happen is that the court will just re-embrace Chevron and say, actually, we think Chevron still makes sense. It was rightly decided and has been applied correctly, and there's no problem here, nothing to see, everybody go home. That's extremely unlikely. And it's extremely unlikely, I'd say, for two reasons. One, if that's what the court wanted to do, there was no reason to take these cases, right? the court accepted these cases very intentionally because it thought there was a problem to solve. Now, does that mean the court is going to go with this maximalist version of overruling Chevron? Not necessarily, because again, there are some justices who, Justice Barrett, Chief Justice Roberts, who are evidently concerned about these downstream effects of flatly overruling Chevron. So what you might see is something, some middle ground decision. And by middle ground, I mean limiting Chevron or reinterpreting Chevron without explicitly overruling it. So what could that look like? One version of this might be that the court says, well, Chevron may or may not have been wrongly decided. We're not going to decide that today, and they can do this. But assuming that Chevron is right, Chevron never meant that if a statute just doesn't address an issue, then the statute is ambiguous. Because again, that's the issue in those fishery cases: is the statute doesn't say whether the agency can make private parties pay for these onboard monitors on fishing boats. So maybe the court just says, well, the statute doesn't address that. That doesn't mean the statute's ambiguous, and send it back to the lower court and say, no, there's no ambiguity here. Apply the traditional tools of interpretation, and then tell us whether the agency got it right in its rationale. That's a possibility. It's sort of a small bore tweak to Chevron that I think would leave a lot of people were expecting some big decision a little disappointed. And it would likely leave the status quo mostly in place, especially for these labor and employment statutes. Because the problem with the labor and employment statutes from an ambiguity standpoint is not that they're sidelined. It's just that they don't give us a lot of detail. Again, going back to the Fair Labor Standards Act and the definition of employer-employee, there are definitions there. The statutes speak to that issue. They just don't really tell us with any degree of specificity what it means to be an employee under the Fair Labor Standards Act. There are judicial interpretations, and now there is an agency interpretation, but nothing in the statute, right? So that kind of decision would actually leave a lot of what agencies have done in the labor and employment space in place, and would likely mean we'd see much the status quo until this issue gets back to the Supreme Court again, if it gets back to the Supreme Court again. That's one possibility. I think a more likely possibility, because again, I don't think the court would have taken this case if it wanted to do something as limited as that, is that the court will say something along the lines of, even if Chevron was wrong or right, we're not going to decide that today. Or maybe they just say Chevron was right, but you misunderstood it, world. You've been misreading Chevron for decades. Chevron never meant that courts should just outright defer to agencies. Instead, what it meant was courts are supposed to apply these quote-unquote traditional tools of statutory interpretation first. And only if they can't figure out what the answer is using their traditional tools would they accept the agency's decision. So essentially, in this version of overruling Chevron, the court would reinterpret Chevron deference and say instead, it only means that you defer to the agency's interpretation if it's toss-up, if everything's in equipoise. So I've gone through and I've applied all these traditional canons of interpretation, which you can find in the case law, which most of them are written in Latin, right? This hoary old stuff we learn in law school. And only if I go through all the whole rigmarole and still can't figure it out, then I defer to the agency. That's a much more limited version of deference. It's a much more limited version of Chevron. It's much narrower than anyone has understood Chevron for the last 4 decades. So it's a possibility. That would be a big deal. It would effectively mean Chevron is a much narrower doctrine than it has been until now, and that likely would affect some of these labor and employment issues we've been talking about. I mean, the last possibility is the court just said Chevron was wrongly decided. We overrule it today. Courts are supposed to apply their own judgment. That's sort of the big nuclear bomb. Everybody loses their mind, and we write 100 articles about it, trying to figure out what it means. That's possible. I don't think that's the likeliest scenario. I think it's one of those middle grounds, what we're likely to see. But what would that mean for agencies? Let's say it is one of these middle grounds. Well, one, if it's the middle ground that I described as more likely, where Chevron is sort of narrowed to this, courts are supposed to apply their own judgment first. Then you're looking at all those effects we described earlier. Agencies are likely to be more reticent in issuing rules. They're likely to issue more limited rules. They're likely to regulate less. And they may go back and take a look at some of the other rules they've passed before. In fact, they may be forced to. This isn't in the slides, but I'll mention there's a case pending in front of the Supreme Court to be over this week, actually, called Corner Post, which involves the statute of limitations of the Administrative Procedure Act. That sounds super boring, I know. But it's actually really important, especially when you couple it with these decisions considering Chevron. And why is it important? Well, the case in particular involves, do you have to challenge a regulation within 6 years of its being issued, or can you challenge it within 6 years of it being applied to you, or you suffering an injury under it? If it's the former, then a lot of rules that have been on the books for years and years and years, and everyone has assumed that they are okay under Chevron, would effectively be insulated from challenge, right? People would not be able to go out and file new lawsuits and say, well, this rule that's been on the books for 20 years is unlawful. But if it's the latter, if I can challenge a rule within 6 years of my being affected by it, then every rule in the CFR is potentially up for grabs. Many of them have been issued under the Chevron regime. Somebody could start a new business tomorrow, be affected by the rule, and then file a lawsuit and say, well, Chevron's no longer around. You don't get any deference. The court has to consider this issue de novo, and I think you got it wrong in the rule. So that that decision coupled with Chevron could lead to a lot more litigation over rules, which would potentially upset the apple cart for many regulations in the labor and employment space that we've been living with for decades. So that's a potentially big change. I mentioned this before, but agencies may find other ways to advance their policy goals. That might be litigation. That might be sub-regulatory guidance, right? So you see the Department of Labor do this a lot. They will issue administrators' interpretations. They did a lot with that during the Obama administration. You may see them issue more fact sheets. You may see them issue more bulletins, opinion letters. These are kind of things they can do without publishing full-scale regulations, which won't get deference in court, but at least will inform the regulatory community about how they're reading a statute, which itself can have some influence on private behavior. If I'm running a business and I know the Department of Labor thinks a piece of the statute means X, I'm going to try to conform my policies to that meaning so that I don't end up in an audit at some point. And that's just rational behavior. So I've been talking a lot. I think I think it's probably time to get to some questions. Stephanie, did we have any questions come in?
Yeah, we actually have quite a few. If you want to review the Q&A box, I can take over for a minute. So thank you so much, Alex, for providing us with that in-depth look at the consequences that we may see if the Chevron case is overruled. Anyone who's in attendance today, we invite you to add any final questions that you may have on this topic into the Q&A box. While Alex takes a moment to review those questions that have already been submitted, I would like to take the opportunity to offer for you to see a complimentary demo of the Navigator Suite. If you're interested, simply answer yes on the poll on screen, and I will send your contact information to our team of experts to have a deeper conversation with you about your compliance strategy and how complianceHR can help support it. Now, as Alex continues to review the questions in the box and you guys submit a couple more, I just wanted to share again a bit more about complianceHR and why we're on this call today in the joint webinar with Littler. So complianceHR is a joint venture between two incredible and innovative organizations, the AI technology company Neota and the law firm that we all know, Littler Mendelson. ComplianceHR delivers expert employment law guidance in a fraction of the time. Our goal is to simplify the complexity of employment law something that you guys should have learned about during this presentation. And to achieve that goal, we do offer a full suite of technology solutions around critical HR compliance topics, including employee overtime, leave, employee handbooks, independent contractor classification, and many more. Now, you may be asking again, how did these resources fit in with today's topic? Well, these two compliance essential solutions are a great fit for answering some of the upcoming potential policy changes we may see as a result of overruling Chevron. Policy Smart is a comprehensive employee handbook solution that provides you with federal and state compliant templates, a compliance policy timeline, handbook checklists, and even automated emails to alert you on new legal changes. And the Reference Center is a solution that combines many of our rapid reference tools. It helps you and your team quickly answer employment law and HR compliance questions with information on a wide range of compliance topics, and it includes deep insights bridging multiple compliance concerns. These two tools are created to help HR, legal, and even compliance professionals do their jobs more efficiently and effectively. So hopefully you understand now that having an up-to-date, trusted solution with data and information directly sourced from Littler, inform your team of these sorts of changes and use that to streamline your HR and compliance workflows really does help your organization save time, money, and avoid any unnecessary stress. All right, now let me get back to our other slide here. Okay. I will leave this poll open until the conclusion of today's presentation. So should you decide you are interested, the Q&A box will be there. You can submit your email, you can click the link on screen, or of course you can visit the complianceHR website in addition to signing up on that poll. Now, to answer one question that continues to come into the Q&A box, I just wanted everyone on the call to know you will receive an email including the recording of today's event and a copy of the slide deck. So please be on the lookout for an email from complianceHR webinars. Alex, were you able to see the questions in the Q&A box or up in the chat?
I was, yeah, and we actually got some fantastic questions. This is a very informed audience. So I'm going to start with the one I have here at the top. Do any state administrative procedure acts, e.g. California, find federal guidance on the subject to be persuasive? In other words, would overruling Chevron have an impact on administrative regulations at the state level? The answer is yes and no. I say yes, as is so often with good questions. No state explicitly relies on Chevron. And the reason is that Chevron is based on sort of a theory about the way the federal government works in the relationship vis-a-vis Congress to the federal agencies, to the federal courts. But that doesn't mean Chevron's irrelevant at the state level. Many state courts have in fact adopted Chevron as a approach to interpreting their own state's regulations. So let's say I'm on the Supreme Court of Ohio. There is an Ohio decision that will say whether or not I'm supposed to defer to federal, or excuse me, to state agency interpretations of state statutes. And many state courts in the heyday of Chevron adopted that framework. This makes sense. We are going to go lockstep with the Supreme Court. But interestingly, what you have seen, and Ohio is top of mind because it falls into the bucket I'm about to talk about, many state courts have stepped back and said, actually, because of all these criticisms we've talked about Chevron, it doesn't make sense. We don't think that our court should be deferring to our agencies, and therefore we are overruling our own Chevron-style doctrine. And so some states have actually taken a step back and already taken this step to overrule, quote-unquote, Chevron within their states. Ohio's done that. There have been a few others. So the answer is, and the reason I say yes, potentially, so the answer is no in the sense that it doesn't apply directly, but yes in that if the Supreme Court were to take this step and say, yeah, the role courts are supposed to be playing is interpreting the law in first instance, other state courts to take that same hard look at it and decide, well, actually, we need to be leaning in and doing our judicial duty as articulated by the Supreme Court and interpreting the law in the first instance. So there's a potential downstream effect, but it's not necessarily direct. Overruling Chevron would not change state administrative law tomorrow, but it could trickle down in the coming years. The next one I've got here is how would the FLSA be affected? This is, it's actually complicated. So the Department of Labor Wage and Hour Division, which administers the Fair Labor Standards Act, gets various forms of deference depending on the issue it's regulating on. We talked about a few of them today. When it's regulating on terms like independent contractor, it only gets what's called Skidmore deference. When it's regulating on terms like the white collar exemptions, it gets Chevron deference. So there would be an immediate effect in how the department has to defend its own interpretations with respect to those Chevron style issues like the white collar exemptions in court. Those interpretations would be more vulnerable. Courts would be taking a look at them by themselves and deciding, well, is this the right way to read the statute? Should there be a minimum salary? Should there be a salary basis requirement? Is that supportable in the statute or not? So that would be an immediate effect. And then downstream, when you're talking about some of these other issues which don't get formal Chevron deference, it's almost an attitudinal change. But what I mean by that is if courts are getting the signal from the Supreme Court that they are supposed to be more aggressively looking at what agencies are doing and making sure that what they're doing is in accordance with the statute, even some of these other issues may be affected. So courts may be taking closer, harder looks at issues that would normally have received Skidmore deference, and they would say, well, the agency's experience, this is debatable, we're going to take the agency's view, and instead really leaning in and doing a hard analysis and deciding, is this actually the best way to read the statute, despite what what the agency may be saying. So there could be different effects for different issues depending on what issue under the FLSA you're talking about. I'm sorry that my answer to both of the first two questions was maybe. Or yes and. Okay, any chance we hear a decision prior to the last date of the court's current session in June? So I'm going to give you the knee-jerk answer, which is no. For those who don't know, the Supreme Court is not like it's not like many courts that are in session all the time. The Supreme Court sits in sessions, and its session starts in October and ends in June. And the reference to June is most of the most important, controversial, difficult cases get handed down in the very last week as the justices are about to head out for their summer vacation. There have been very few cases, well, I shouldn't say that. Look, everybody thinks their own issue is the most important. But this is certainly, without a doubt, one of the most important cases that the court is going to decide this year, if not in the last decade. So I don't think there's much chance that they issue it before June. They're probably going to hold it to the end, just like they usually do with these big important cases. But look, anything's possible. They don't actually have to hold it through June. I wouldn't expect it. Can you say more about how the landscape of current rules would change if Chevron is overruled? So we talked a little bit about this. I can say a little bit more. Current rules won't be overturned immediately, right? It's not as if somebody's going to walk out and say, well, the whole Code of Federal Regulations, all these books I have on my shelf, these are all garbage now because Chevron is gone. That's not what you're going to see. What you're more likely to see is piecemeal litigation over existing rules. So there will be instances in which an agency tries to apply a longstanding rule to a private party, and that private party, being adequately represented, will raise as among its defenses, well, this rule is a bad interpretation of the statute. The agency got it wrong. And court, you're no longer supposed to defer to the agency's view. You're supposed to give it a reading on your own. And once you read it on your own, you'll realize that this isn't necessarily what the statute means. So there will be more of that. How much of that there will be? So I'll give you two answers. One is that no one can actually quantify this ahead of time. We don't really know. There's too many variables. But what I will tell you is that as somebody who's been practicing in this space for a long time, and you have someone who is being charged with some regulatory violation that is not clearly supported in the statute, then you'd be foolish not to raise that as a defense. I mean, just in your self-interest. So there's likely to be a lot of that, particularly if this statute of limitations issue we talked about with Corner Post goes the way that it could go, which is that there effectively is no statute of limitations that runs from the date the rule is issued. It runs from the date you were affected by it, the injury first accrues. So, we could see more or less. I think there's likely to be a fair amount of that. Let me see. When will we see the decision? Probably the last week of June. What would be the impact of Chevron on regulations implementing executive orders? For example, the new pay transparency rule on the Procurement Act, which seems like a thin reed to me. That's a really excellent question. So off the top, executive orders usually, not always, and you hit on one, usually govern the conduct. Oh, I'm sorry. I think we're already a minute over. Stephanie, can I just give a quick answer to this before we log out? I don't want to leave people hanging.
Yes, absolutely.
So
the CLE insurance certificate links were sent, so everyone should have any data they need if they do have to log off. Sorry, Alex, go right back and do it.
Okay, yeah, I'll just do this very quickly. So executive orders usually don't raise these kind of issues because they are usually instructions to the rest of the executive branch from the president, though sometimes they do affect the rights of private parties, like the example the questioner just gave. And in that instance, the executive order itself falls in the same category as a formal rule by the agency in that it is an executive action interpreting a statute, which is now running up against private rights, in which case if Chevron goes away, then the executive order doesn't get deference, and nor does any regulation issued under the executive order. So yes, this could affect regulations interpreting an executive order. And I say could, would. It's the same principle. Okay, well, I just want to say thank you very much to complianceHR for having me. This is such a fun topic. Thank you all for spending your afternoon with us. And if you have any questions, you know how to reach us. I think my contact information was in the presentation. Thanks again to complianceHR for the partnership.